Welcome all for joining us for our 20th annual Developmental Disabilities Spring CPD. I'm Greg Gillis. I'm a family physician in London for many years, and I've been a member of the Developmental Disabilities Program for many years. And we actually comprises of myself, a family physician, Rob Nicholson, who's a pediatric psychiatrist, and Jay Rao is a psychiatrist with a dual diagnosis designation from Britain. And we have these annual sort of continuing medical education programs, which have been very successful and with lots of useful information for the attendees. And usually we'll get a broad spectrum of individuals, primary care physicians, pediatricians, psychiatrists, other health professions like nurse practitioners, nursing, and people who are, and sometimes educators who deal with individuals with developmental disabilities. So to begin, I need to read the next slide, I guess. So I need to read these aloud. Disclosures. So this program has no financial support or sponsors. And Dr. Nicholson has no relationship with financial sponsors. He does get some grants, research support from the Ontario Brain Institute, the Brain Canada, Hoffman LaRoche Limited, Otsuka, and MapLight. Myself, I have no relationship with financial sponsors, but I do speaker or honoraria sometimes for Servier Canada. And Dr. Rao has no relationship with any financial sponsors. So Dr. Nicholson is not presenting, but is the chair of the Developmental Disabilities Program. I am not presenting, but I will be moderating the event, and no topics are planned about these funders. You can use your smartphone to scan the code on the right to view the agenda, or option 2, you can visit the ddp.uwoca website, and that will show you the program and will be highlighted in blue. So, is Dr. Nicholson going to say any comments?
Nope.
So we'll move on to our first presenters. So the topic is going to be the public guardian and trustee's role in financial and treatment decisions. So it's my pleasure to introduce our two speakers today. Charles Walters, who was called to the bar in 1991, has been regional counsel with the Office of the Public Guardian and Trustee in Southwest Region since 2005. His practice area prior to joining the Public Guardian and Trustee included estate planning and estate and incapacity litigation. Prior to joining the PGT, he frequently appeared before the Consent and Capacity Board as a patient counsel, and as counsel at the PGT is involved in all legal financial issues of incapable PGT patients. And our second presenter is Rhonda Kearney. Rhonda graduated from Western with an honors BA in 1994 and has been with the Ontario or the Office of the Public Guardian and Trustee since 2000. Since joining, she has held various positions in property guardianship services, became an investigator in the investigations unit, then joined the treatment decisions unit in 2013 as a treatment decisions consultant. Treatment decisions consultants act as substitute decision makers of last resort on behalf of incapable people in Ontario. Prior to joining the the Office of the Public Guardian and Trustee, Rhonda was employed at the hospital formerly known as the London Psychiatric Hospital. So just a quick comment, this is an area that in medicine is oftentimes very confusing for physicians and dealing with patients with developmental disabilities, individuals with dementing processes, and sometimes conflicting issues regarding guardianship and the power of attorney and stuff, especially where you have two people who have dual responsibility but differing opinions. So anyway, welcome to our program.
Thank you, Dr. Gillis. I guess I'm going to kick off first. Rhonda, it sounds like we've been around a little bit. My name's Charlie, and Rhonda and I are here to give you a brief overview of the PGT's role both in finances and treatment. I won't be presenting a paper today. Rhonda may have some PowerPoint that she's going to present. For both Rhonda and I, it's been our experience that these presentations are best served when we field questions. So our presentations will not, well, mine won't be long anyway. I don't think Rhonda's will be overly long either. We're happy to take questions at the end. And from the questions we received in advance, it looks like there's going to be a fair interest in treatment decisions, which is more Rhonda's domain than mine, but we'll see how it goes once we're done our presentation and where the questions from the group take us. I thought I'd start with, how does the PGT become a guardian of a person's finances? And there's really three main ways. The first way I'm going to talk to you about is the Mental Health Act. When a person is admitted to a hospital for psychiatric care, the attending psychiatrist is required by law, by the legislation, to examine them as to their capacity to manage finances. If that psychiatrist is of the opinion that the person is incapable of managing their property, they issue what's called a certificate of incapacity, the C of I, we call it. Once a C of I is issued against the patient, it's then sent to the public guardian's office in Toronto, who look at the document, vet it for accuracy, and then the file is assigned to a caseworker at the PGT's office, depending on where the person lives. Our region covers, in the Southwest region, everything from Windsor to Owen Sound. Doesn't capture Kitchener, but it's a very big region. One of the important considerations is that the obligation to assess a person only arises if that person is going to be admitted for psychiatric care. So it's an important distinction, because you're probably, some of you are aware, there's you can have an assessment for 72 hours, a 3-day assessment period. That's just a time period when the person can be reviewed by a physician to determine whether they should be admitted as a psychiatric patient. So it's only once a person is being admitted as a psychiatric patient that the obligation to assess then arises. And it's only if the admitting psychiatrist makes a finding that they're incapable that the PGT becomes guardian of property. The obligation to assess a patient is said by the case law to be forthwith, and by the legislation. And forthwith generally seems to mean within 3 or 4 days of admission. So when they're admitting a psychiatric patient, they're supposed to review them. Can they manage their own property? And if not, issue a C of I. It's also important to note that if someone is on a psychiatric admission, so let's assume they get admitted for psychiatric care, and on admission, the treating psychiatrist does not assess them as incapable, they could be assessed at any time during that admission if the treating psychiatrist wants to do that. So later on, it could be 2 weeks in, the psychiatrist could do another assessment, and maybe he or she will conclude that the person is now incapable. Alternatively, they might conclude that the person was incapable on admission, but now is capable. So these assessments can arise both on admission and throughout the admission. What happens when the person is discharged from a psychiatric facility is important as well. Again, when person's being discharged, they must be assessed by the treating psychiatrist as to whether they continue to be incapable. So they may have been found incapable on admission. They may have continued to be incapable through a part of their admission. Now it's time for discharge. Maybe that patient has been accepting of a course of treatment. Maybe their condition has improved. So the doctor is then required to do another assessment to say, are they better? Can they manage their money now? If the doctor is of the opinion that the person has regained capacity, they can discharge them without doing anything. That terminates the public guardian's authority over their finances. Conversely, if the doctor is of the opinion that the patient remains incapable on discharge, they're required to do a notice of continuance, which is a continuance of the finding of incapacity. So what that happens is the psychiatric patient they transfer from being a person on admission, a patient throughout their admission at the psychiatric facility, discharged, they again become a person, but they're still subject to the notice of continuance, still under the public guardian and trustee. If a patient is discharged without a notice of continuance, we see this happening more than we'd like, but if they are discharged without a notice of continuance, and it's an error, sometimes steps have to be taken by the facilities to say, I didn't mean to discharge them without reassessing them. And we sometimes get into a bit of a conflict with the facilities to say, well, we need to correct this. If that person is indeed still incapable, you have some obligations, and we try to work with the hospital to repair that situation. If a patient is discharged with a notice of continuance, meaning the public guardian is still their guardian of their finances, the PGT's authority can be terminated as well. So they're no longer in the psych, they're out in the community, they're under a notice of continuance, but it can be that someone comes forward and says, I am an attorney under a power of attorney. Before that person was admitted to the psych, they had done a power of attorney appointing me to manage their affairs. If one of those people come forward and sign the appropriate documentation to the public guardian and trustee, our authority is generally terminated. I say generally because there are some limited exceptions, but once they submit the appropriate documents, PGT is no longer the guardian, and the job is taken over by the attorney that the person appointed. And as I know from my past practice, psychiatric patients can also challenge the findings that they're incapable by going to the consent and capacity board. Board set up to review findings of incapacity, and the patients have a right to those hearings. They have a right to counsel. They have a right to challenge the finding. And occasionally, not very often, but occasionally the findings are overturned. And if that finding is overturned, the public guardian is no longer guardian of property. A second way that the public guardian gets appointed is quite apart from the mental health system, nothing to do with it. If a person is not a psychiatric patient, the Mental Health Act cannot be used to certify them incapable. The mechanism that's then available is something called an assessment under the Substitute Decisions Act. And imagine most of you are familiar with assessors. We call this a Section 16 assessment. We call the Mental Health Act assessments Section 15s. We call the assessments under Section 16, Section 16 assessments. Capacity assessors may not be doctors. They can be social workers, they can be nurses, they can be clinicians. They are people who have undergone specific training on how to assess capacity to manage property. And they're subject to a variety of specific procedures they must follow in assessing someone's capacity. So if you have someone out in the community who's not a psychiatric patient and not likely to be, but there are concerns about their capacity to manage property, how do you get a capacity assessment? Comes up a lot. Well, the public guardian's office maintains a list of capacity assessors. There's people that have trained and retrained, and they maintain themselves on a roster so that if someone was to call in, they would be entitled to receive a list of those assessments. By the way, I see there's a question. Are we going to wait till the end on questions, or will we deal with them as we go? I'm just asking the moderator.
What I'll do is if we can have the questions at the end of the presentations, okay. And then I was negligent in mentioning that at the front end, and then also if you do use the raise hand option, and then we'll track that, and then when you do have the question, we'll get you to unmute and carry on from there.
Okay. So again, if someone is concerned that a person is incapable of managing their property, they could get the name of a capacity assessor from the PGT's office, fill out the requisite forms that are required, and request a capacity assessment. And if a capacity assessor conducts the assessment and they determine the person is incapable of managing property, applying the test that they're required to apply, the finding is sent to the public guardian and trustee's office. And again, it's assigned to a representative of the public guardian and trustee to begin management. Some important limitations about assessments, though. They're different than the Mental Health Act assessments. A capacity assessor generally can only assess someone if they do not oppose the assessment. Okay, so if you were to contact an assessor and say, I'd like you to assess the capacity for Bob, and you fill out the form, and the assessor goes to Bob, and Bob says, get out of my house, I'm not going to be assessed. That's it for the assessor. They can't assess. So there has to be no opposition to the assessment. Another restriction is if you were to request an assessment for Bob and the assessor goes to see Bob, and it's discovered that Bob has a power of attorney in place. So Bob appointed somebody last year to manage his financial affairs. Again, the assessor cannot perform that assessment. The only way that an assessor can perform an assessment if someone has a pre-existing power of attorney is if Bob were to request the assessment himself. Doesn't happen very often, but if Bob were to request that assessment himself, it doesn't matter that there's a power of attorney in place. The assessor can do the assessment. But if the request is from somebody else about Bob and there's a power of attorney in place, assessor can't do the job. They can't do the assessment. A question that comes up a lot is, how does a person terminate a guardianship that's been obtained under Section 16? We talked about the Mental Health Act one, where that, you know, they can be reassessed by the psychiatrist and they can be found to be capable. With the Section 16, a subsequent assessment by an assessor saying, I've reviewed them, they may have been incapable 3 months ago, they're not anymore. That terminates the public guardian and trustee's guardianship over their affairs. Nobody then has authority over their affairs. A third, I don't know if it's less common, I guess it's less common. A third way the public guardian might become involved in somebody's affairs is through court order. The first two are really just legislative paths to have a guardian appointed. The third way is if it goes before a court. And sometimes it is necessary to go to court to have someone appointed. And for example, you could have someone who doesn't have a psychiatric admission, doesn't have a psychiatric history, will not agree to be assessed under Section 16, but appears to be doing things that suggest incapacity. What are your options? They may be, this is not atypical. We'll see someone who may be living in a house that they've inherited from an estate. They've been living there for 10 years. They're not paying the property taxes. The utilities are shut off. They're hoarding. It's in squalor, and they're generally not caring for themselves. These happen more often than we'd like. Under the legislation, which is the Substitute Decisions Act, the public guardian could choose to bring a guardianship application against that person and to go to the courts to say, this person's not doing well, they need a guardian. And oftentimes what they'll ask the court to do is direct the person be assessed whether they consent or not. Oftentimes, the way this is initiated is we'll get a call. Someone in the Toronto office in the investigations department will get a call from someone saying, Bob's not doing well. I've known him for years and he's in a very difficult situation. I need you people to get involved. And our office will take some steps to investigate. I need to emphasize that we do not interfere lightly. It has to be a pretty severe situation. It's only where the person is at risk of losing a significant part of their property, or they're completely failing to provide the necessities of life for themselves or others, that the public guardian is going to be involved. So it's essentially like a two-step process. The call might come through to the public guardian, send an investigator who starts to make inquiries. Sometimes that's where it ends. They make a determination that the person, while odd, and while not acting in a manner that we would like, are not incapable or don't appear to be incapable. They know that they're not paying the utilities and they know that they're not paying property taxes, but they understand that. And if we come to a determination that we don't think that there's enough grounds to have the person incapable, we may close our file. If we think there are grounds, we could take it to court and seek to become temporary guardian with an order that they be assessed, and perhaps finally to become a guardian. And the public guardian is also brought in to be guardian in court proceedings where family members start this. So Bob has a brother who knows that Bob is not doing well, and the public guardian chooses not to investigate, or chooses, they think they don't have enough evidence. Bob can bring the matter before court, and maybe Bob or Bob's brother could bring the matter before court. And if Bob's brother has a sibling, that person may have something to say about the court application as well. Sometimes the public guardian gets dragged into those otherwise private matters because neither Bob's brother nor sister can agree that either one of them will manage the affairs, and a request will come for the public guardian to step in as a neutral third party. And once there's a court order in place, appointing the public guardian, or in fact anyone. The only way that can be changed is by a court order. So essentially think of it as three ways that the public guardian might be involved: under the Mental Health Act, by assessment, or by court order. And again, my comments are limited to financial issues. There is another mechanism by which, if the public guardian is appointed as guardian of property, let's say under the Mental Health Act, or because of an assessor making a finding, not talking about court orders, but by those two methods, family members can apply to replace the public guardian. So they can fill out the appropriate application form, propound a management plan, and ask the public guardian to approve them to replace. And if everything seems to be appropriate, the public guardian can agree to let that person take over. And the last area that happens actually a fair bit that we see, and it may be something that you run into with your patients, is we will occasionally resign in favor of an ODSP trustee. So if we are appointed as guardian of property for someone by virtue of them having a Mental Health Act admission, we become guardian. And after some investigation, we determine that the client's only asset, their only asset is ODSP. And the only thing that's being managed is ODSP. And if that person already has an ODSP trustee in place, I don't know if you're familiar with these forms, but it's a way of someone who's receiving ODSP appointing someone to manage the funds for them. We will sometimes resign in favor of that ODSP trustee, as long as that's the only asset. So that's another way that the public guardian can be removed from someone's life. As a final point, what I'd note is that you might ask, well, what can a PG2 do if they're guardian of property? And the answer is simple. Anything the person can do with their property except make a will. So it's a very, very broad power. And with that, I'll turn it over to Rhonda.
Hi. So I am going to attempt to share a screen. First of all, I'm Rhonda. I am a treatment decisions consultant at the Office of the Public Guardian and Trustee. I'm one of 13 consultants in the province, and our main job is to act as the substitute decision maker of last resort for people who are incapable in Ontario. So I'm going to, I brought a PowerPoint slideshow. I'm not going to go through every slide, every point on every slide, and I'll probably miss a couple of, I'll just skip by a couple of slides. But if you have questions about those things, we can talk about those in the end as well. So I'm going to attempt to do this. Oh, here we go. Maybe Sarah can give me a hand here because she has my, oh, maybe it's, Sarah, could you give me a hand by any chance?
Of course, 1 second.
It looked easy on the video. Ah, thank you so much. Oh, perfect.
So just let me know when to forward the slide for you. Okay?
Oh, yeah, okay. Oh, because I can't do it from here. Okay. Okay, so I'm here just to talk about the role of the PGT, specifically under the Healthcare Consent Act, making treatment decisions on behalf of incapable people in Ontario. As I'm sure you're aware, in Ontario, nobody may be given medical treatment without consent unless it's an emergency. And of course, people who are capable can make those decisions for themselves. And if a person is found to be incapable of providing consent to their own treatment, and there's nobody else in the hierarchy in Section 20 that we'll talk about, the Healthcare Consent Act requires that the PGT will make the treatment decision as a substitute decision maker of last resort. This is just the definition of what an emergency is. We can just kind of skip by this one if you, Sarah, thanks. So these are kind of the components of how treatment decisions are made under the Healthcare Consent Act. So treatment must, under the Healthcare Consent Act, must be proposed by a health practitioner who belongs to a regulatory college. Of course, they propose that treatment to the patient and or their substitute decision maker. The patient or substitute decision maker can then ask for clarification about the treatment or additional information about the treatment. And then eventually they'll make a decision to give or refuse consent to that particular treatment. So it's under the Healthcare Consent Act, it's up to the healthcare practitioner to A, determine capacity, and B, determine who the highest ranking appropriate, well, I don't like the word appropriate for a few reasons, but who the highest ranking decision maker is under the hierarchy in section 20. So there's a list there on the left-hand side of health practitioners. It's not an exhaustive list. Notably, pharmacists aren't on that list, and they can now provide treatment, including vaccinations, and I'm not sure what else. I also understand that board certified behavior analysts may become health practitioners under the Act when they eventually join the College of Psychologists, which I understand is kind of coming soon. So, sorry, could you just back that up just a bit? Oh, sorry, that's fine. I already made that point. Go ahead. Thank you. So, capacity. So, the practitioner, you know, the Healthcare Consent Act talks about a presumption of capacity. So in the absence of any information that would suggest that the person is incapable, a health practitioner is entitled to presume that they are capable of providing consent to their own treatments. Capacity, it should also be noted, is dependent on treatment. So for example, somebody who has schizophrenia may not, you know, when unwell, may not be capable of consenting to their antipsychotic medications, but could be capable of consenting to, let's say, their diabetic medications. Capacity also depends on time. So like in the previous example, so the person with schizophrenia may be unwell, but with treatment, they become well again and they regain insight and, you know, they become capable and then can make their own decisions. So, and on the right is section 20 of the Healthcare Consent Act. So, and I think there were a lot of questions around, you know, how do you decide who is the highest ranking substitute decision maker? So section 20 is your friend. So it lists the hierarchy. So the highest ranking substitute decision maker would be a court appointed guardian of the person. So either the PGT or some other person has gone to court and asked to be made a person's guardian, and the court has granted them that power. Second is an attorney under a power of attorney for personal care document. Third is a consent and capacity board appointed representative. Then it gets into family, right? So spouse or partner, and, you know, below them, child or parent. Notably, in terms of parents, the custodial parent outranks the non-custodial parent. And then it goes to siblings, then any other relatives, and last but not least, the PGT as the SDM of last resort. So when the PGT or any SDM is making treatment decisions on behalf of incapable people, the Healthcare Consent Act what's the word I'm looking for? The SDM must take into account, first of all, any prior capable wishes the person may have had, and those can be in any form. That could have been, you know, a conversation that their cousin remembers from 5 years ago. It could be It's something that's more formalized in a power of attorney document. So yeah, it can be expressed in any form. It doesn't have to be, it's not a formalized thing. So in the event that there are no known prior capable wishes, or if it's impossible to comply with that wish, then the SDM must take into account the person's best interests, including their values, beliefs, their incapable wishes, and also how the treatment would affect, hopefully improve the person's quality of life and their condition and well-being. So the Healthcare Consent Act also defines what is and what is not treatment. I won't go into too much detail there, except to say that one thing to remember is that consent is not required for treatments that pose little or no risk of harm. So I know the one example I can think of off the top of my head would be, say, some kind of antibiotic cream for, a minor skin rash. Certainly that is a treatment, it's a prescription drug. However, there's little or no risk of harm, so a health practitioner may determine that consent is not required for that decision. Again, I'm not going to go into all of these specifics, but in the event that you do contact the PGT in order to discuss a treatment decision, we're going to have a conversation with the health practitioner and potentially other parties, depending on what the decision is. But we're going to want to be provided with information about the nature of the treatment being proposed, the expected benefits of that treatment, what the potential risks and side effects might be, if there's any alternatives, say it's a particularly intrusive procedure, we're going to ask about, if there's any less intrusive alternatives, or if any alternatives have already been tried. And we're also going to want to know what would, we'll likely ask what would happen if the person did not receive treatment. And that's pretty much it. So there, at the end of the PowerPoint, there's links to all of our brochures. You can get them easily online by Googling OPGT brochures. We've updated them recently, so they look really nice. And that's it for my slides. Thank you.
Okay. I'm not coming up, but thank you very much for very informative presentations. I'm sure we'll have a number of questions. If people could just use the hand up option, and Sarah can moderate that. And then when you do have your questions, just unmute for our speakers. Sarah, do we have any takers?
Yep. First up is Dr. Goldberg. Just unmute yourself, please, Dr. Goldberg, and you're good to go.
Sarah, could you perhaps remove the presentation, because I think it, there we go.
Thanks.
Dr. Goldberg?
Yes, I guess to both of you, have you had people, well, we were talking today about the developmentally handicapped. Have there been situations where people have taken advantage of the developmentally handicapped in terms of making decisions for them that they really shouldn't? Because developmental handicap is a spectrum from severe up to mild to borderline. Have there been situations where there have been some unscrupulous family members taking advantage to take guardianship?
Will I start, Rhonda?
Yeah, well, the short answer is yes. Do you want to speak to that on the property end of things?
I do. We see it all the time. It's sadly the bread and butter of a lot of stuff that we do. So we may end up becoming a guardian because there's been a course of financial abuse of someone over the course of 3 or 4 years. And once we're appointed as guardian, we step into the shoes of that incapable party and try to redress that wrong. It might be through police involvement, it might be through a civil action, but yes, we see it all the time. We also see it, even though it doesn't happen very often, Rhonda touched on it, on the personal care end of things. We're not nearly as often appointed guardian of the person because of the way Rhonda described the hierarchical decision-making you already have for treatment issues. The situations where we do become guardians of the person and get involved in medical and treatment issues are usually where there's been abuses or failures to properly care for someone or failure to have them get treatment. So we see it. I think we get jaded because we just see the bad stuff. We don't see a lot of the good stuff.
Okay, Rob, you have a question?
I have many questions, and so I thank you, Charles and Rhonda, because I think this is an area, especially with children and adolescents, perhaps, that comes up all the time. So I will start with just one question for now, but Charles, when you were talking about, that there was for inpatients in psychiatry, there's this particular process, and for outpatients, we can use an assessment under Section 16. I guess.
Well, outpatients actually is interesting because there is some argument that you're still a patient while you're an outpatient because you haven't been discharged.
Well, I don't want to sound like a lawyer, but even what does an admission to a hospital actually mean? Is that like if somebody's seen in a hospital, are they admitted to the hospital?
I used to litigate that a lot before the Consent Capacity Board, and it's not it's not an easy question to answer. But essentially, we look at the documentation that is filed when the person is actually admitted as a psychiatric patient, and it's got to be clear that they're admitted. So you can't have somebody who's in there with a broken arm, and then you do an assessment saying, "Oh yeah, well we have a Psych 1 facility, and the doctor did a walk by, so yeah, they're admitted for psychiatric care. So therefore, we'll do an assessment as to capacity." That would be challenged. The outpatient one is a little more interesting question. It's best to get the advice of the hospital as to what their documentation looks like. But my view, and Rhonda, you correct me if I'm wrong, you've got a lot of history on this stuff, is an outpatient can still be a patient. They're not discharged from care. They're just not in the facility.
So I'm thinking more people who've never been admitted to an inpatient unit, right? So just typical outpatients in any hospital. And so what comes up in my practice a fair bit is people as they're 16, 17, getting closer to 18. And we'll talk, people with more, let's say, more significant intellectual disabilities who aren't able to manage their finances. Parents will often ask, what should we do about this? Do we have to do anything about it? Since there is a clear hierarchy and there's people already in place, do we actually, is an assessment under Section 16 even needed?
There's only a hierarchy for medical, and then Rhonda will tell you that. There are no substitute decision makers for financial matters. Unfortunately or not, I don't know. But certainly if the person is 17 and turning 18, the SDA with respect to property only applies to people over the age of 18. There might be a possibility for someone who has a developmental disability. They might still be able to do a power of attorney. That's a question for a lawyer that might be meeting with them to do it. But once they turn 18, they can become under all of those same procedures that I described for the Substitute Decisions Act. Does not apply to children, and children being someone under 18.
But once somebody turns 18, are we obligated especially if somebody's still living at home or something like that, are we obligated to do an assessment of their financial capacity?
I don't think so. It's an interesting problem because you have people who are 16 with jobs, don't you? Receiving a paycheck. They're not really a person under the law. For the purposes of the Substitute Decisions Act. So it's quite a gray area, but the SDA does not apply when they're under 18. You can't do an assessment of a person's capacity under the SDA. Now, that being said, there is an ability, if there's somebody who comes into some money and they're under the age of 18, there's something called the Office of the Children's Lawyer, and there's something called the Children's Law Reform Act. And what it allows is a bit of a mirrored legislation where you could step forward to become guardian of property of somebody who's under the age of 18, but it's a different procedure. It's a different office with different onuses and different tests. It's not very often that you're going to have somebody who does have assets while they're under 18, though.
But
Right?
I'm thinking more once people turn 18.
Yes,
they're
that's
still
when the
kids.
SDA kicks in.
But so even if people are still living at home with their parents, as a physician, am I obligated to do an assessment of their capacity to manage their finances?
I don't think you ever are. The only people obliged to do an assessment of capacity to manage property is a psychiatrist admitting a patient to a psychiatric facility.
So
if
then,
you're-
no, sorry, go ahead.
No, go ahead.
Because I was gonna say, because parents, as people get closer to 18 or when people are turning 18, parents will sometimes say, what do we need to do? Do we need to do
Yes.
anything? What I've been told is that if they're still living at home or if there's still a parent involved, I don't necessarily need to do anything.
That's not actually true. What'll often happen is, what assets does this person have? So
Yeah,
if they're
none.
turning
I mean, they're
18,
ODSP.
if they're turning 18 and all they've got is ODSP, remember the ODSP trusteeship, right? So they can go down to the ODSP office, assign their parents to have the ability to manage those funds. And if those are the only funds they have, and that's the only asset that they have, it's going to work. The problem you get is they may be on ODSP and then a grandmother dies and leaves them $40,000. That ODSP trusteeship does not cover that asset. It's limited to the ODSP monthly benefit. That's when you get into problems. But if your only asset is an ODSP monthly income, I mean, you know how much of that's left over every month after the care costs win? Nothing, right? So it's money in, money out. We all kind of hold our nose and let that go through.
But if families go down to get an ODSP trusteeship, if somebody is still living, does that cost families anything?
No, it's
Does
a
it-
one
does it
page.
take
It's a
away
one
their
page
rights?
form. It's a one page form. I think
Does
that's
it
what,
take
isn't
any
it,
of their
Rhonda?
rights?
So, Rob, just to follow up on Rob's question, so there are a lot of people with adult children at home with severe developmental disabilities, and then the question is like the whole assessment thing, because there's a cost to it. And then, so the ODSP trustee, but say the person's not able to sign off on that to have their parents do it.
Fair question. Then the only other option is going to be you order a Section 16 assessment, and there is a fund to pay for those through the public guardian's office if there's no funds that the incapable person has to actually pay for that, or there's no funds that the requester has. You would apply for an assessment. If the assessment proceeds and the PGT becomes incapable, the family members would then apply to terminate the public guardian and trustee. They then become guardian of property.
Okay, then that's all written out, and going forward, they're okay.
They are then the guardian of
Yeah,
property.
because that exists out there in huge numbers.
I know.
And
It's a problem, but there is no hierarchical list of decision makers as there is with treatment issues. There is no such hierarchy.
So I may have misunderstood what you're saying, Charles, but because I'm a bit confused now, because I thought you said that it wasn't necessary to do an assessment on an outpatient, but I thought now you said that it is.
No, I'm saying there's some argument that while somebody, if they were admitted to a psychiatric facility, become an inpatient, treated for 2 months, become an outpatient, continue under treatment, but on an outpatient basis, I say that there's still an ability, if the person is incapable, I think it's arguable, there's an ability for the treating psychiatrist who's treating that outpatient to still say, well, they're an outpatient, but they're still a patient. They've not been discharged from the hospital. So I can still, if I feel they're incapable, issue a certificate of incapacity. Again, that's advice you'd need to get from the hospital council. But my view is that there is still that ability. They haven't been discharged. It's the discharge that changes everything.
But if they've never been an inpatient,
I don't know how you become an outpatient if you've never been an inpatient. That's an interesting distinction. I don't know how that works.
So if we think about, Dr. Gillis is a family doctor, somebody comes to his office, and does he have any obligation to, if that person's 18, to assess their capacity?
The only obligation arises when they're admitted for care for psychiatric treatment to a Schedule I facility. That's when the obligation arises.
And admitted for care means sleeping overnight?
There's a form they do, isn't there, Rhonda?
Form 1.
No, the
But
form
that's
one,
against,
Form,
that's against-
form one's the application for the
21.
assessment. Form 21.
Okay. Perfect, thank you.
There are
Okay.
still some, yeah, there's still some questions in the Q&A. And Dr. Rogers, I think, had at least one question. So if I allow her to speak, she can unmute herself and ask the question.
Hi, so I'm a social worker, and so I really appreciate your conversations because this is often something that comes up with parents. I've worked with parents, and then I've also worked with adults that have had developmental disabilities. And so I've witnessed way too many times of individuals being taken advantage of. And so trying to support parents on how to prepare and avoid difficulties is one of the things that I would like to really inform families for. So one of the things that I've been confused about, but I think, Charlie, you answered that question with regards to what's the difference between before 18 parents applying for this piece as versus after it. So I think I got the answer to that one, so thank you. But one of the things that I haven't been able to find online, and so I'm hoping you can point me in the direction, is a brochure that would provide parents or caregivers of individuals with a child with a developmental disability or a budding adult that would go about how to, what are the pros and cons of this? Certainly, what are the pros and cons of being the power of attorney versus being getting the public trustee to oversee, as well as what are the steps required in order to be able to access that. So if there was something, I would be thrilled.
Rhonda, do you know if the brochures that you linked there? I think they're in. I think they're in
Yeah,
those links.
yeah. So you can either follow those links in the PowerPoint, but if you just Google, we've just recently updated all of our brochures. So if you just Google OPGT brochures, it comes up like pretty much right away.
They're quite good.
Yeah, they are quite good.
Well, and I haven't looked probably in about 6 months, but
They're better.
well, I was terribly excited to see your presentation because this is one area where I've struggled to get my head around, and yet it is so critical. I've seen it go so wrong for young adults when they don't have these appropriate checks and balances in place in order to ensure their safety.
But your question about, is it better to have the public guardian versus family? I mean, I'm going to tell you that we do the best we can, but we have a lot of clients.
Yes.
And we do the best we can, and you're not going to get the same level of service that you might get from a family member. Now, not all family members are appropriate. Sometimes we're a good solution when you've got poor decision makers in the family, but that's why the application to replace process is there for the financial end. If for public guardian, and the family members find it problematic to be dealing with this blunt instrument called the PGT, they can apply to replace us. And if they satisfy the public guardian that they're going to do the right thing with the financial aspects of the person's life, they'll replace us. We don't want the files. We have too many. We're happy to get out of the files where we have the appropriate people to step forward. But they've got to take the steps to show that they're going to look after that person. And, you know, I got to think for the most part, somebody who's caring for a disabled adult and is in their home, I don't know what complaints we'd have. Well, sometimes we do, but I can't think we're going to have a lot of complaints about that person managing their finances. And we'll make sure we put safeguards in place if they do get appointed.
Yeah.
Does that make sense?
Absolutely. The only time I've had it make sense is when there's been a contentious care or a grandmother has been the guardian, and they just don't want to fight with their individual about money. So that's the only time I've heard them say, "Well, I'd rather it go to the."
Some people like the distance.
Yeah.
You know, they say, "Stop calling me. Call your worker at the PGT."
Yes.
Yeah.
So, but I am going to go digging, and
they're
I
good
really
brochures.
Thank you.
I think next
Great.
there's a question from Dr. Nyman. So you are allowed to speak. If you unmute yourself, please go ahead.
Thank you. So just as context to the question, I know what I would do clinically in this scenario, but I'm just wondering about a legal lens. So that's the context. So the question is that the legislation pertaining to healthcare consent and substitute decision-making are fairly clear with respect to the process for determining capacity or lack of capacity, resulting in an informed decision-making process with the decision maker. If a child who lacks capacity communicates that they are not in agreement or are dissenting to the proposed treatment, and the proposed treatment is voluntary, such as a medication, but you have a parent who has capacity, who's provided the informed consent. I'm curious what the legal lens for physician guidance would be on considering assent in an incapable child. So clinically, a child can protest aggressively, making the regular administration of something like a medication difficult.
I think this is going to be more you, Rhonda.
Yeah. So the child, you're saying that the child is incapable?
The child's incapable, but in complete disagreement with the proposed voluntary treatment. To what degree legally do physicians need to consider assent or agreeability?
So yeah, I think you're right. That's a legal question. And I can't really provide legal advice. I'm just trying to, so.
When you say the child is legally, is incapable, so they're not unable to understand the treatment or not, you're not saying it by virtue of their age, because you're probably aware that age does not render incapacity.
Right.
But if they're, how would it be different, Rhonda, than any
I don't know that it would
patient?
be. I don't know that it would be.
No.
I mean, it's problematic in the sense that, if they're adamantly opposed to whatever treatment is being proposed, then, then it becomes an issue of like, well, how, say it's an oral medication, how are we going to, how is that going to work?
Right.
And if I'm a physician, I might be talking to my hospital counsel about a application to the Consent Capacity Board for some direction. Because then it's off you put the case to them and people can make their position known, and then a directive can come from the board. If you simply don't feel you're getting instructions or not instructions, but proper consent, you can seek the direction of the board, I believe.
But it doesn't sound like that in this case. It sounds like the parents are in agreement with the treatment, but the child is not.
Correct. Yeah, and the child lacks the capacity, the appreciation, and understanding.
So it gets interesting then. What they're not really, if they lack capacity, then their objection is non-capable objection.
Right.
It's interesting.
There's still considerations. I know because in working with physicians and so forth, I know that there's always concerns about the therapeutic relationship and all of those things. But I don't know that the situation with the child would be any different from, say, somebody acting as an SDM for another adult, and that adult, the incapable adult, objects to, certain kinds of medication.
I think that's a fair comment. I don't think that adult versus someone over the age of majority really changes the analysis.
Yeah. And it just kind of works out, either it can work out a number of different ways. Either, maybe because of the, to save the therapeutic relationship, you decide to try another option, or, maybe it kind of depends on what the circumstance is and what the treatment is for. And
sure, yeah. So I think clinically, I would sort of want to navigate through this by exploring with the child, what the concerns are, et cetera, and trying to work towards the assent. But I was just, so that's what I would do clinically in this situation. But I was just curious about a legal lens, like legally a child who is saying absolutely not, and is almost sort of requiring to be restrained to provide oral medication. but lacks the capacity. I'm just wondering from a legal perspective, if the physician continues to prescribe the medication, knowing that this is the scenario, is there any sort of concern in that situation?
Well, you always have to have informed consent whenever you're
Yes.
giving treatment. So if you feel that you've received informed consent from the substitute decision maker and you've satisfied yourself that the person objecting doesn't have capacity to direct treatment,
Well, I would think that the child, like an adult, would have the option if they disagreed, they could, with the finding of incapacity, even they could still go to the consent and capacity board and say, and you know.
I would think that, yeah, I've never seen that, but there's no
I mean,
reason they
either,
couldn't.
but yeah,
Okay, thanks. Appreciate the dialogue.
Thank you.
you're welcome.
Any more questions, Sarah?
Yeah, I think there's one from Dr. Ogilvy, so let her speak. Find her name, that would help. Maybe she is not here.
So
Anyway, there
maybe-
is one more question from Dr. Nicholson, so I'll.
Well, I don't know about him.
I don't either, actually. And I apologize for dominating things, but you know, what we Jackie, I think you probably just unmute in the bottom left-hand corner.
Oh, there you go.
And Sarah, could you maybe just remove the slide?
So what we've had an issue with here at CPRI several times is children who are not living with their parents, but there's no clearly identified legal guardian. So we've had several situations where a child has been placed with an aunt or an uncle or somebody else, but there is nothing on paper to say that that person has custody. So we've seen several kids who have a letter from the CAS saying, you know, yes, to the whoever the kid is living with, saying this is to confirm that so-and-so is residing with you. But that's kind of a pointless letter, I would think. And so there's, you know, in terms of treatment, if there's no actual legal guardian identified, who is the legal guardian? And this comes up with people in group homes as well, if they're awarded the CAS, because I suppose in theory, CAS social workers should be showing up for each appointment, but that's not the reality of what happens. And so in those situations, what are our obligations?
Rhonda, do you ever deal with CAS
Not
treatment? I almost
not directly, because they if somebody is, you know, is under the CAS, then the CAS typically has guardianship.
They're
right?
ward of CAS. They're
Yeah,
a
so
ward.
they act
But
as guardian
But in
until
these
they're 18.
situations, in the situation I'm thinking of, the CAS has taken a child out of their parents' home, placed them with somebody else, but the CAS has said they are not they haven't taken custody of the child, the CAS.
But that would mean the CAS is still they're awarded the CAS until there's a permanent guardianship granted. That, I mean, you probably need to get the CAS lawyer to clarify,
Yeah,
because it's generally
We've
going to be
tried.
a proceeding. What's that?
We've tried, and they've generally been disinterested, I would say. And they said, you know, we've provided a letter saying that this child is residing with Mr. and Ms. X, but that, I mean, saying where a child lives doesn't really mean anything.
no. Well, and in that case too, I've seen, this comes up occasionally. So the child's had involvement with the CAS, but they're not necessarily, I guess, a ward of the CAS, and they're in like a family home program.
They're placed,
something like
yeah.
that. People say, well, we can't go to the parents because CAS, they're awarded the CAS, and the CAS says, no, we're, you know, because they're 18 or whatever, we're not acting in that capacity as their guardian. People.
Again, are we talking about someone who's necessarily incapable as well? That's the
Right.
threshold.
Yeah, absolutely. I mean, so the person may
Sure.
be, you know, 10 years old and not able to consent to medication treatment or something like that. Or if the person's older, would have an intellectual disability such that they aren't, I mean, they could consent for a Band-Aid or something like that, but not for medication or something, or some other assessments.
Yeah, I would say, well, you know, again, I can't give legal advice, but Section 20 would define a relative as by blood marriage or adoption. So if there's no adoption, it's just a placement. I would, you know, I've seen it happen before where they actually go back to the biological parents for consent.
So in the
Because
one
they're
kid,
able, willing, and available.
so the one person I'm thinking about, his mother is dead and father is homeless and not available.
Okay. Any other relatives?
Well, so in that one person's case, he's living with his aunts and uncle. So using the hierarchy, are the aunts and uncle the default legal guardians or the default substitute decision maker?
It sounds as though they would be the highest ranking decision
It's
maker.
interesting though, it is interesting, Rhonda, when he's talking about guardians, we're mincing our words a little bit.
Right.
Guardian under the Healthcare Consent Act is not guardian of a child. It's
Right.
court appointed guardian. So when you look at guardian, don't think of a parent as a guardian. The highest ranking person to make substitute decision makers is a guardian if so appointed. There's almost never going to be a guardian court appointed for a child.
Right. It's going to rely on section 20
Yes.
and the family hierarchy. So
Yes.
if mom's deceased, dad is unavailable, you know, the siblings are under 16, because I think in the SDM portion, it does, you know, they have to be over 16. So no siblings over 16 who are capable, willing, and available. You know, follow that down, you know, they would be any other relative. So, and in any event, they would outrank us as the SDM of last resort.
Yeah.
Okay, that's really helpful. Thank you.
Okay.
You're welcome.
I think there was,
Yeah, Dr. McDoom has his hand up.
Jacqueline Ogilvy is going crazy trying to get LinkedIn.
I know, I don't even see her name in the list of participants. I have no idea what is happening with her Zoom connection, but unfortunately, I don't even see her as a participant to allow her to speak. So we're gonna let Dr. McDoom have this one.
Thank you. So it's hugely problematic when we say that age doesn't render one incapable, because technically what that means is that a 6-year-old can say, I'm refusing to get my appendix out. And go ahead.
Sorry, there is the problem you have is we're just saying under the legislation. It's not just age. At six, I think the case law would tell you a 6-year-old does not have capacity to consent. But the general rule seems to be, I think it's 12, isn't it, Rhonda? The case law.
Oh, is there case law? I'm not sure about case law, but I know that there's no, you know, it's
There's
not
no,
like you become
no age limit.
16. No, yeah.
There's
So
no age limit under the
technically-
legislation. What's that?
So technically, that's what that means, that a 5-6-year-old can say, I am refusing, otherwise, air quotes, otherwise normally functioning 5-6-year-old can say, no way, you're not coming close to me. I don't want this appendix out. If it bursts, I don't care.
No, but
I
are
think
they
that-
capable of making that decision?
Yeah.
Are they able to understand and appreciate, right? Are they understand the proposed treatment and the consequences of, you know, the foreseeably reasonable consequences of making or not making a decision or refusing consent, right?
Just because they say they're not going to consent doesn't mean that therefore it's a valid refusal, right?
But isn't that what the consent is? That if a individual who you don't have any other reason to believe that is getting in the way of making a choice, that's why there is no age for consent, right?
Correct. But you'd inform yourself, you'd talk to them about what the elements of the treatment are, what are the pros, what are the cons, you discuss it. And if you don't think they understand or have the capacity to consent, and I can't believe there'd be many 6-year-olds that could, I could be wrong, I would think you're going to say, I can't take your instructions here. I cannot take your consent. I'm going to go to the substitute decision maker on this one.
And that's why I said this is hugely problematic, because when we are dealing with these children that have obvious limitations or the reasons to believe that they can't decide certain things, we are holding clinicians still responsible for making some choices, some decisions, like locking the doors. That technically we can't lock the door to a facility, even if a child has the tendency of running out, because that's just the legislation, that's just the law. Certain facilities are not qualified for that level of care and support, So doors stay open, child runs out, you follow them as long as you can. When they disappear from your visions or line of sight, you call 911. So this is what I mean, that this is hugely problematic, that we are having to deal with these situations on routine, regular, daily basis, and law says one thing and some other parts of legislation say something else, and then the clinical decision making something completely different.
Are you talking about like a group home setting?
Sure.
No.
But I think, so Hale, I think what the law says is that you can't presume a lack of capacity based upon a person's age, but they still have to be able to, they still have to have the capacity to consent to something. So you can't automatically say that a 6-year-old can't consent to having their appendix up just because they're 6, but you could say they don't appreciate the consequences of their decision or lack of a decision, and therefore they're not capable of making that decision.
Right, but what about locking the doors to the units?
And is that considered a treatment though?
It's not treatment.
No.
Well, containment is treatment because
The whole restraint issue that you've probably heard over the
Yeah.
years. Yes, our ability to contain them, to implement any programming, any treatment, makes it part of treatment. We are not gonna be chasing them on the streets while we are trying to problem solve and reason with them that was the right decision and was the wrong decision and this is not okay and you shouldn't be doing this.
No, but and also wouldn't the whatever organization that has the responsibility for that child's care, would they not then have a common law duty to keep the person safe?
Well, I don't know if Dr. Nyland, you want to take on that part?
We see the same thing in the chronic care hospitals with people with dementia. We have wards where they're locked wards for safety. And although the whole idea of restraint is a dirty word, but they formulated different ways for safety. And so that sort of supersedes.
Right.
Anyway, any other questions, Sarah?
Well, I'm going to read Dr. Ogilvy's question because she can't figure out
Here
how
she
to.
is.
So the question she had was about traumatic brain injury population. So most of them, or some of them, have large settlements and might not have the capacity to manage them. So as a physician, would she expect that the structure of the settlement would assign the guardian and cover all that?
This is mine. It happens all the time. That's how we get many of our patients. We will get a call from a lawyer representing a family on a motor vehicle accident, and they advise us that the person cannot instruct because they have a brain injury, and maybe the family is not an appropriate decision maker on the litigation, and we will often get appointed. Any party who is settling a lawsuit and is a party under disability, and the definition is somebody who just simply can't understand how to manage property, any settlement must be court approved. A judge must look at the settlement. When a judge looks at the settlement and the person is compromised, there must be a very detailed plan set out for what's going to happen with the money. And what generally happens, I'd say 90% of the time, is a structure is put in place. And you probably know what a structure is, but it's essentially an income stream generating over the next 40 years or whatever. So the settlement says, this person's going to get $1 million. This $1 million is going to fund a structure that's going to generate $10,000 a month for the next 40 years, $12,000 for the next 10. And there'll also be a guardian appointed to make sure that they manage that money. So the funds will never get into the hands of the incapable party directly. So there's generally a court approval settlement, a guardian appointed for the incapable party with a management plan set in place. So it's all controlled. Does that make sense?
Yes, yes.
Can the guardian overrule the structure? No. In America, they can. You can sell a structure. You cannot here. So the structure is in place. The only way you could possibly do it is by going back to court to amend that initial court approval judgment. So that income stream stays in place unless a court were to order otherwise.
Okay, great. I think what we'll do is sort of wrap it up there. And thank you both for very interesting presentation. I'm sure there's going to be a run on your brochures.